Okay.
Too much work, is it?
No, I had the flu.
Okay. So at any point of time, you're not up to it, we can always do a part two whenever. So don't worry about pushing yourself,
Thank
right?
you.
Because obviously your inputs are very essential, but we can always take them as we go along. So Chitra, what we're doing is, the mediation legislation, and I had put it out as I don't know whether you saw the promo. Basically, how, what, when, where, which, who, why. Let's question everything. Let's not. I mean, it's an open thing. We can do it. We're not the legislators. We're just trying to push the legislators. So this is what we are doing. And of course, we have now 50 speakers from 30 countries, and I'm still going to maybe extend it. Let's get more views on this. So that's what we're doing. So Chitra, it's all yours, about yourself, and then let's take it from there. We'll come in when you want us to come in. So please.
Thank you, Vikram. I'm so happy to be on this show finally. Mediation legislation has been something that's been dear to me. Since 2015, I quit mainstream practice I stopped going to courts, and I said I should focus on working in mediation. And one of the things that I thought was important was having a legislation on mediation. And I started drafting a law, or what I thought would be needed in a law for mediation. I didn't for a minute actually at that point in time question the need for the law. And there were two reasons why. I thought positive law would encourage the use of mediation. And I felt there was a lot of confusion about what mediation was. Is mediation the same as conciliation? Is it the same as arbitration? And I felt that we needed clarity in terms of policy on what mediation was, and having a law on mediation would encourage, would clarify, would put the force of a policy or the law behind the process of mediation, and would encourage its use. The second reason why I didn't think twice about the need for a mediation legislation was because there were several policies. We have so many policies, either in terms of laws or regulations, that include mediation as a part of dispute resolution. In fact, in India, we've tried so many approaches to mediation in the regulations that we have already. We've tried mandatory mediation, we've tried mediation as a part of a multi-door court process. We've tried mediation as a process of as a dispute resolution continuum in certain sectors, such as micro small enterprises, where you are required to attempt mediation or conciliation and then move on to arbitration. We have ombudspersons in certain specific sectors like banking, insurance, who work to resolve disputes that customers may have with banks or insurance companies, and who will also attempt mediation before they resolve the dispute on its, on the formal issues that are raised by the customers and the companies in turn. You have mediation, which is part of the Family Courts Act, that you will attempt mediation in a matrimonial dispute. And so the Companies Act has provision for mediation of disputes relating to companies. So there are many, many laws that are there that make provision for mediation, and therefore, it was in a sense a given that you have laws already. So it's not like it's a clean slate and we're looking at this question of should we legislate on mediation. So these were the sort of two broad contexts in which I looked at it.
Chitra, can I just come in for a second? There is a little disturbance. Are you sitting somewhere where there's a breeze blowing or something? Because there's a
No,
okay, okay,
my
okay,
fan, let me just turn that off.
okay. No, you can't switch off the fan. You need, you need that. But it's just like, there's something with that when you're outside and the wind is blowing and it hits the mic, that kind of sound is coming somewhere.
Okay, let me just turn it off. So that'll make it easy. Just give me a minute. I hope it will be better now.
Yeah, much better. Well, you're a strong and loud voice for mediation in the country. So that loud voice has to come out loudly. It was a little too soft somewhere.
Okay. Yeah, so I didn't think to question if we needed a legislation on mediation because it was already there. We've So we have, like I said, uh, lots of policies relating to mediation that have attempted multiple approaches to mediation, mandatory mediation, um, or providing the facility for mediation, which a person can opt for because the law is there, which is, for instance, there in Part 3 of the Arbitration and Conciliation Act. You have court annexed mediation, which then gives parties the option of trying to resolve the dispute themselves through panels of mediators who are available as a part of a court annexed facility. You have mediation, which is built into certain categories of disputes, specifically for those, and you attempt mediation in resolving certain types of disputes. So different approaches to mediation have been incorporated in laws that are there, which then leads us to the question of do we need another legislation on mediation? As we're all aware, there is a bill on mediation which is pending before the Rajya Sabha, the upper house of parliament. We've had a committee look into this bill and make suggestions on what changes needed to be made. So this bill is there, and a lot of the initiative for a law on mediation came from the mediators themselves. So why did we think we needed a law on mediation? One was the fact that there were multiple policies on mediation, and there was a confusion on what is mediation, what is conciliation, do we have a law on mediation at all? We had points of view that said conciliation is so different from mediation, it is not the same, please don't mix the two up. We had laws relating to mediation and conciliation. For instance, in Part 3 of the Arbitration and Conciliation Act, which was so prescriptive on what a conciliator would do. It said you have to do this, this, and this, and this, and only then is it conciliation under Part 3. We had a lot of confusion about, including from judgments of courts, on whether a tiered dispute resolution agreement that parties had, where there was a provision of for conciliation, when there was any confusion about it, the court said this wasn't enforceable. You have laws that talk about mediation, and the same person or body of persons who will mediate, if there is no resolution, there is no settlement, will then go ahead and make a decision on the dispute. Right, so the same set of persons who are listening to confidential information, who are encouraging parties to settle their dispute, now have such information available to them to actually decide, the dispute. You have laws that work at cross purposes with mediation. For instance, you have laws for arbitration that stipulate that the arbitration will be completed within a time period. You have the same law that says you encourage parties to try mediation and try and settle their dispute, but this time that will be taken for mediation or for settlement is not excluded within the time limit, and therefore that then discourages the use of mediation there. Just the use of mediation to resolve disputes, is not excluded in the general law of limitation. You have provisions in the contract law which say that any agreement in restraint of legal proceedings is void. It excludes arbitration, but it doesn't exclude mediation. So if I have an agreement that says that we must go for mediation before we go to court, I mean, it might fall afoul of this provision. So you have like many laws, but you also have a lot of confusion about what mediation is, what the rights of parties are, how are we safeguarding it, what do we understand by volition in mediation, what is the extent of confidentiality protection that is available to parties in a mediation. If you have a mediation and you enter into a settlement agreement, what is the status of the settlement agreement? Would you be able to enforce it? Do you enforce it as an agreement? The law seemed to suggest that if it was conciliation, then it is as good as an arbitration award on agreed terms. But a lot of lack of clarity there, because can you challenge an arbitration award which is actually a mediated settlement agreement? If so, on what grounds? How long did you have before you challenged it? All of this was sort of up in the air. Finally, we have the Singapore Convention. India is one of the earliest signatories to it. There are now 11 countries that have signed that have ratified the Singapore Convention. The United Kingdom is looking very seriously at doing so as well. And if we are looking at international settlement agreements, we must have the benefit of the Singapore Convention that will encourage the use of mediation in international disputes, which are commercial in nature. So all of these issues were up in the air, and it does help to have an umbrella legislation that would address all of these issues, that would give parties certainty about the process, certainty about the outcome if they were to participate in the mediation, and really sort of to elaborate what mediation means. So there are compelling reasons for having a legislation in mediation that will sort of take care of mediation generally. You could have sector-specific or area-specific, laws governing mediation or frameworks governing mediation that serves the purposes of that particular sector. So that was a purpose, and that's where I see a need for a mediation legislation in India. We do now have the mediation bill that is there before the parliament, and the question is, does this meet these needs that I see as being necessary for mediation? There is value in this bill in that it addresses it seeks to address mediation generally, and it defines mediation in a very all-embracing way. It says you can call it by whatever name it you want, but any process in which parties have a dispute and you have a third person who's assisting them to resolve the dispute would amount to mediation. And so all these, is conciliation, mediation, is mediation where online systems are used, mediation, all of these questions now fall away. But that said, it is my view that the bill has not addressed most of the concerns that one hoped would be addressed in the bill. And in fact, I think what the bill does is to sort of puts mediation in a straitjacket, and it sort of takes away from the flexibility and the the what should I say, the accessibility of the process, right? So, and if one looks at how it safeguards rights of parties in a mediation, again, I think there are a lot of questions that come up in the context of the bill. So, just to sort of speak of a few elements of the bill and to sort of talk about where we need to see some changes in this bill before it is passed. The first is that the bill mandates mediation in all civil and commercial cases. And I think it is important to encourage the use of mediation through requiring parties to attempt mediation. And that's one way of building awareness in mediation. But to sort of introduce mediation as a mandatory process across the board for all disputes that are civil or commercial in nature, I'm not sure that is the way to approach it. We need to have a little more nuance. We need to have a little more of deliberation on how we introduce mandatory mediation. So it is important then, if we look at mandatory mediation, to introduce it in limited sectors, in one or probably more than one sector, but in very narrow areas, to see how mandatory mediation works in these sectors. We have attempted it in our Commercial Courts Act. We used it for commercial disputes. And as you are aware, there is a lot of churn about how this is to be implemented. You have questions being asked by the court on whether an interim application for urgent interim orders that parties make before the courts, whether you have the courts now sort of second guessing and asking, is this really an application for interim reliefs? And when we do this, what we are doing is in fact putting people off mediation, because we must leave it to parties to decide if there is an interim application and interim orders that they need, and not interfere with their right to be able to go to court for such needs. So without evaluating how mandatory mediation would work, or mandating mediation before filing a case in court would work in the specific sectors that we have introduced them in, to sort of apply it across the board for all civil disputes, I think is going to be problematic, because we are we are A, without building capacities, B, without seeing how mandatory mediation works, we're just sort of making an imposition of this. And I think there is a problem. We also have language used in this enactment which says that unless you have exceptional circumstances that you are able to demonstrate, you will have to first attempt mediation before filing a case in court. Given that we've seen enough churn when the law has said that if you have an interim relief that you need, and that exempts you from attempting pre-institution mediation, to use new expressions like exceptional circumstances when we don't know what this really means is only going to cause a lot of problems by the time we figure out what exceptional circumstances are, and when persons are warranted as having exceptional circumstances. I mean, I think this is going to set us behind quite a bit. And also cause a lot of resentment in terms of parties feeling that they're being deprived of access to the courts. The second sort of problem with the bill is that it bureaucratizes the process of mediation in many ways. It says that you will have to register your settlement agreements. It says that you will have to conduct mediation in a place where the court has jurisdiction over the dispute. It says that if you have community mediation, then the community mediation will be conducted by persons from a panel that is established by the Legal Services Authority or by the district magistrate, which is, the government then sets up a panel, and it is only this panel that will mediate community disputes. So you have all of these elements that are there that sort of constrain and constrict how mediation will be conducted. Requiring mediated settlement agreements to be registered, I don't see why that is required. I also worry about what that means in terms of safeguarding parties' rights to confidentiality. Now, if you have a repository of settlement agreements that are maintained by government agencies, who has access to them? Can the government access them? My choice of mediation to resolve a dispute is a part of my autonomy, and I must be free to keep the mediated settlement agreement confidential, to choose whether I want to implement it or not implement it, leave it as it is. And these sort of freedoms are now being taken away by the bill, by mandating that I must register a settlement agreement. We have a provision of a mediation council that is provided for in this bill, which will regulate how mediation and mediators and mediation service providers and mediation institutions will function. To my mind, all professional bodies should be independent, should be run by the professionals themselves. This allows for persons who are most familiar with this process, with the profession, to be able to manage their affairs themselves, to be able to self-regulate, to be nimble, and who best to regulate us than ourselves, right? So there is another problem, because the mediation council is something that will be set up by the government, and the persons in the mediation council will be persons largely appointed by the government, and it's not a democratically elected body that is going to run this process. The one good thing about this bill is that it does, in some way, in a very limited way, make provision for mediation to carry on without falling within this institutionalized setup, or so you have persons who are not necessarily trained or registered as mediators under this bill, who will be free to continue with their mediations. And in that sense, it is good, because I don't think it is mediation in India. It is a plurality of mediations that happen in India, and that the law or the bill does not mandate that all mediations must be in the manner by registered mediators and as specified in this law. I think to the extent that it gives this space for mediation to continue without regulation in the manner that the bill provides, there is benefit in that, and I think that's really useful. One of the requirements of a law on mediation was to make a provision for enforcement, for recognition of mediated settlement agreements and for enforcement of these settlement agreements. The bill says that this will be enforced as if it were a decree of court. If it is a mediation conducted by these mediators, but it provides for very strange grounds for challenge of a mediated settlement agreement. It doesn't sort of take into account the nature of a settlement agreement, which is that it is an agreement, and that, like a contract, it could be affected by other factors such as fraud, coercion, or the grounds that are available for one to challenge or question an agreement or avoid an agreement. So there are limited grounds that are put in here which don't all sort of align with what the mediated settlement agreement will be, and that is something that needs to be addressed. The last point that I would make on the bill is the fact that it doesn't make any provision for the Singapore Convention. It also does not make any provision for international settlement agreements that could arise in other areas of disputes other than what is covered by the Singapore Convention, which is commercial disputes. And it provides its own sort of framework for commercial settlement agreements that might be international or domestic, which means that you will have now a certain jurisprudence that will develop on the basis of this framework. And when we decide at some point that we want to introduce the Singapore Convention, you're going to have, excuse me, two parallel frameworks that are running insofar as both commercial disputes as well as international commercial disputes are concerned. So this is sort of what I wanted to speak on the legislation. It is also important for the legislation to address issues that I had indicated in other laws. For instance, the Legal Services Authority says that the permanent Lok Adalat will attempt mediation and then will, if there is no settlement, will decide the dispute on its merits. Is that advisable? Should we not have some safeguards on the same person mediating and then deciding the dispute? All of these are open issues, but these are laws that have been kept outside the mediation bill. So these are concerns that still remain. And so according to me, there is a lot to be worked on this bill before the Rajya Sabha considers it. A lot to be corrected, a lot of consultation, I think, is necessary, before we finalize what the mediation bill will be.
Thank you, Chitra. The only thing, can we call it the X bill? Is it possible to call it the X bill? Because it's just happier that way. It's the X bill because look, it's gone back. It's not going to come back in the same form, hopefully.
I hope so.
So can we call it X bill?
Okay, yes.
Because look, I'm hoping that of course, whatever suggestions have gone back from the standing committee, okay, I mean, for me, that bill by itself is an issue. So if they've gone back and there is some sense which prevails, maybe things can be changed totally. I hope. I'm just optimistic. I'm an optimistic person. So I'll just look at it that way. But I don't know where to start, because look, either way, let's start from conciliation itself. And can we start from that structure and say, okay, this doesn't seem all right in this, so this needs to be changed in this way. Is that possible to look at it from that? So start from there, because yeah.
So you're suggesting that we don't have a bill at all, but
we'll come to the thing.
We look at the law we have on conciliation and see if we can work with that law to address issues that one is talking
exactly.
about.
Is it by itself? Because look, this part, I've always been saying, and I'll still say it, is for me, it's one of the best laws for mediation available from my perspective, because I always look at it from this person sitting in a village. I have to go from there because 1 billion people in this country live in villages, and from there for their access to courts and all is a big issue. Lawyers, what they do with them and all, that's an issue. So how can we do something for them where they've got something which they can work with on their own? Read it, a simple language, read it, understand it. Of course, mediation word we are using, but of course in the Hindi translation of the act of conciliation, it says Sulh. Sulh is still a word that they will connect with. So connect them with that word, because of course that's in Hindi. I'm sure in Kannada or in Tamil, there will be some words which people connect with. So we're not stuck with the word at all, because definitely in our own country, we're not stuck with it. Sulh is available because it's there. So I'm just saying, looking from their perspective, when you look at this structure of conciliation, do you want to change it, and what would you want to change?
So when we're looking at making changes in Part 3 of the Conciliation Act, the first thing I would probably say is, please detach it from the Arbitration Act. Put it in a separate legislation, because I think it needs to be said that, it is a very different process from arbitration. Why should it be coupled with the Arbitration Act? be separated so that people look at it, on for its own worth, for its own process, as distinct from arbitration. That is the first thing that I would probably say we need to do in part three. The second is that we define mediation, and we define it by its function, its essentials. That this is a process where two or more persons are attempting to resolve disputes that they have through discussion, and there is a third person who is assisting them in this discussion and who does not have the authority to impose settlement on them. We say this is what it is. So then when people talk about conciliation, because there is no definition in part three, so when people talk about conciliation or mediation, they understand this is it. And as parties, we know that whoever it is who's helping us in resolving this dispute cannot impose anything on us. We may ask that person to suggest a way in which that person thinks a settlement could be arrived at, but that's that. It's up to us. I mean, that autonomy needs to be recognized in.
What I'll bring in, Chitra, is let's just bring in the definition of mediation in the Singapore Convention. And we can also look at it from the model law, 2018 model law of UNCITRAL. Are you okay with this definition, or you would want it to be different? Well, I'm just saying what we already have. Let's look at those things that we have, and then let's see what needs to be, if there's any tweaking required. So this is what the Singapore Convention says. Then I'll take you what the model law says.
Model law. The Singapore Convention's on the previous
No, this is what the Singapore Convention defines it as.
No, this is the model law.
No, model law is different. Well, I'll show you the model law. The model law, does it change? Can you see
That's the model law?
So this is how it defines. Mediation is defined like this in the model law, and that is the Singapore Convention.
No. If you go back there, the previous thing.
This is, I have put this. This is from this is on my website. So I've taken it from the Singapore Convention and I put it here.
No, Vikram, the previous column, the first column.
Okay, here, I'm sorry. I have to be here and I've moved it there. I'm sorry. So this is how the Singapore Convention defines it?
Yeah, this is a good definition of.
You're okay with it?
Yeah.
Okay. And then the model law, is there anything that you feel out there?
Yeah, makes a reference to contractual or other legal relationships, which I think may not be necessary.
Perfect. So this is how it stands on these. This is how it's, let's look at it from here. Okay. So this is what, this part is the only thing that you think a little bit of a relook as to. But tell me, Chitra, when you look at the X bill, in that definition, why did they leave out the aspect of doesn't have the authority to impose a solution? Any thoughts on that?
No, I really don't know.
I mean, because look, I'm somewhere in, you must have been part of the discussions somewhere on when this was put up. Were you on the definition? No. Because I'm just saying we have all these things lying. That means if you change them, was there some thought process behind it? Were these issues where they have these cases where someone is doing the mediation and then becomes the arbitrator in that? So they looked at that and they say, oh, let's just leave this out.
In fact, the part 3 of the Arbitration Conciliation Act talks about a person who's acted as a conciliator not acting as a lawyer or an arbitrator in the same dispute unless the parties consent. So there are a lot of things in part 3 that can be adopted.
Yeah. But then when you look at any other provisions in the model law that they've put out, which you think should not be there, or because look, we have this framework. I'm sure a lot of people sat together and had the discussion, and then that model law came up. So let's utilize that, because reinventing the wheel, yes, we can always try it, but is it ultimately coming out as round or is it going to be square? I don't know. So what in that model law do you see anything that you felt did not was an issue, or I mean, I'm sure you have your thoughts on the model law. Anything specific that you felt was an issue? We can go through it. I mean, I don't think. Look, you've got all this on your tips side. I need to look at it.
Not really.
Okay, so international law part of it, let's just for the moment
National
leave that
yeah.
that we can leave out.
There is, if you come to 14, I think, if I'm not mistaken.
Okay, number appointment of is not a problem. Conduct of mediation. Are we okay with it? Do you want to put? But I'll tell you why I'm saying that all these things have been put down simply is for that person in the village to see, okay, this is what it talks about. So anything you felt was not required. All these are okay. Termination of mediation, not a problem.
Yeah, not a problem at all.
This is good. Mediator acting as arbitrator definitely is a good thing to put out there. Yeah,
Yeah.
resort to arbitral or judicial proceedings.
Right, yeah. So this, in fact, actually sets the principle of when, you know, while mediation is underway, that you could have the need for arbitration or judicial proceedings in order to preserve your rights. That's, an important point. Sorry, what I was asking for was 15 on enforcement. This doesn't talk about how it is enforceable. It just says that settlement agreement is binding and enforceable. Is it enforceable as if as a contract? Is it enforceable as a decree of court?
How I look at it, Chitra, is that because obviously this is just a guideline, and then based on your own jurisdiction, the way you would want, like in our case, in the conciliation, we have said as good as a consent award, which is as good as a court decree kind of linkage. In your country, however you want to link it is up to you. This is just, for me, it's just a framework given. I mean, framework because every country will have its own way of going about it, and saying it here might have become difficult for them. So I'm looking at it from that perspective, that giving you an idea that this is something that is enforceable, and how you want to make it enforceable, please go ahead with it based on your country situation.
Yeah, so, the earlier model law, which was model on conciliation, international commercial conciliation, said, the provision on enforcement said that it will be enforceable, and it left it blank, saying, you adopt your own method of conciliation, of enforcement. And countries, of course, do have their ways of enforcing settlement agreements. But here it says it will be binding and enforceable. It doesn't say how it will be. You're right. I could, in my country's law, decide that it is enforceable as if it were an agreement, or that it, with some oversight by the courts, it might become enforceable. Like in Singapore, their mediation law says that parties could take it to the court, which will then evaluate the agreement on the basis of certain factors. And then, once the court approves, then it is enforceable as if it were a judgment of the court. So that's another way of, oversight plus enforcement. The third is to say you've entered into a settlement agreement, and it will be enforceable as if it were a decree of court, which is what X bill says. So
Yeah,
these approaches are available too.
look, because it's one aspect you spoke about, that the I mean, being something which is like a consent award, and then how do you challenge it? But you don't think section 34, because it applies to it, will be enough to look at the grounds to challenge it? Or you need, I mean, because I'm saying the linkage was made for that reason, that there are grounds to challenge an award. So those provisions are there, and they linked it to that.
I don't think it was intended at all. The framework in 34, you might find one or the other ground that you might be able to use, in the context of a settlement agreement, but I don't think that was the purpose at all. For instance, it says principles of natural justice not met. I mean, it's clearly inapplicable to mediation. So that wasn't the intent, and therefore I think we shouldn't,
Link it to that.
force fit.
No, but the grounds that you see in the Singapore Convention, are those grounds you think all right, or you would want to in some way look at some other grounds? Because supposing you want to put it in the section, say conciliation section, and you want to say that these are the grounds on which you can challenge it, what would those grounds be that you would want to put?
The Singapore Convention grounds are good, but these are grounds that are very specific to a context of a commercial dispute. You would probably need to look at additional grounds in the context of other types of disputes that may be available. For instance, if you have a dispute relating to rights to, say, a joint family property, you would of course have to take into account if the law specified something that was intended in a particular culture and in a particular jurisdiction, in order to protect a certain vulnerable section, then you would want the settlement agreement not to fall afoul of that. For instance, another example, and I think this is a clearer example, is in the context of children's rights. That may be a part of a settlement agreement. For instance, custody. Are we then this settlement agreement will need to be reviewed, I think, as a matter of course by a court, because it concerns a child. And second, you will evaluate this on grounds that are not your typical grounds of capacity, etc., but are the interests of the child affected in any manner? And so, depending on the type of dispute, you will need certain additional safeguards that are there in the grounds of challenge.
But Chitra, the other thing, my two-word theory, I've been putting out this two-word theory that we need two words for the reason, let's look at it from the arbitration perspective, from Section 30 perspective, that the attempt to settle it through mediation, conciliation, or any other method. So it's put out there. So I've been saying, I was talking to Mr. Panchu also in his session, that the option of going for mediation, in that using those two words, is mediation, you stay in the arbitration, you settle it, come back to the arbitrator passes a consent award. You go for conciliation, you go out of the arbitration, you go under this part 3, you settle it, that settlement agreement is as good as a consent award, so you're now not coming back to the arbitrator. Now, if you have just one word, what would it, in an arbitration, if you're in an arbitration and you say that you go for mediation, and you have one law on mediation, which is a standalone law. So now you've gone out of the arbitration, because we have to have a terminology for two things. One is, of course, from the arbitration perspective. I'm giving you that example. In general, there will be obviously a third person being brought into a lot of disputes, but the person does not want to utilize the benefits of the mediation act. There is a mediation act for a moment. There's a standalone act. It doesn't want to use that, nothing at all under that. They don't want to do anything under it. They just want to sit with someone and settle it. And there's just whatever they sign. It could be a verbal contract, it could be a written contract. It's up to them, because those things are still going to go on. It's not that those are not going to go on. Everything is not going to come into the framework of the act. Now, like conciliation requires a written settlement agreement, but agreements can also be verbal in our country. I'm sure in lots of countries this can be. So those kinds of situations will also happen. Now, what word would we use for that? So when we say this is mediation, then tomorrow, look, lawyers are lawyers. They'll say, this is not mediation. Mediation has to be under that act and has to be written. Now, this agreement of yours, which is a verbal agreement, is not valid. And things like that might come up. So I'm just saying two-word theory. Mediation outside any legal provision, it's outside the act, and in the act is conciliation. Or call it Chitra's method. I may call it anything you want, but I'm saying that you need two words or not. I mean, my thoughts are that, but please, your thoughts.
I don't think you need two words at all. Once you've identified what this is in terms of its essentials, and you showed the Singapore Convention definition, which is a useful definition, I think it encompasses what we want to see in it. Once you've identified that there are ABCD rights that are available to the parties in the process of mediation, and as an outcome of the mediation, you do it either under the framework of the act or outside of it. It should go. And if, as parties, I think that I need to get the benefit of the act in terms of giving it a status, giving it enforceability, then I opt to do it in terms of the act. Why should we call it? Why should we have two words for it?
For this reason, but only thing is, look, Chitra, I've tried to go outside the usage of parties. I've been saying participants only because it comes from an adversarial thing, and I've been trying to. I've been putting that out, and it came from the World Mediators Conference. Jeannie, she works in community mediation, and she said, "In when we work, we don't use the word parties." So I like that. I really like that. So I use participants. I'm just putting it out. So, but this two-word thing, I'm saying, let's look at it from the arbitration perspective only. That go and settle it, or they'll have to say settle it through with the assistance of a third person, and then not call it mediation. But the moment you use that word, that if that word has a definition and has an act to regulate it, then you have gone under that act. And once you've gone under that act, that settlement agreement will have its own way of enforcement. Now you will not be able to come back to the arbitrator to part a consent award, because you've got that provision. That settlement agreement is as good as a court decree on that end. So will you be able to come back, or and because you want to use the New York Convention, you don't want to use that because New York Convention has maybe more enforceability available to you. So you say, look, I don't want to go out of the arbitration. I don't want to use mediation as in the act. I want to, of course, get a third person in, and call it some other word. I'm not saying call it, but call it some other word so that there's no confusion in it, because lawyers are lawyers. Again, they'll say this, now you cannot come back to the arbitrator. You went under mediation, that provision, that act. Now that applies, and that means that by itself is a complete thing. It's happened. Now it's gone. Now you can't come back to the arbitrator, and the arbitrator cannot pass a consent award. So they'll challenge it on that grounds. And in India, that's 14 years of someone's life gone. So so I'm just saying that why leave these kinds of things available to lawyers to do? Make it simple, where there are two words. One is that you want to utilize the law on mediation. The other is you don't want to utilize the law, but you still want to get a third person in.
I'm not sure the use of these two words or parallel sort of systems will in any way reduce the possibility of a dispute where someone wants to make a dispute out of it.
The other thing that Chitra, you have to throw light on the aspect, like you said, building capacity. Building capacity definitely is a huge thing to happen, because I mean, in terms of numbers, in terms of disputes, we know they are huge. I mean, numbers in terms of course, let's not even go into the pending. How many go into courts and how many don't even get into courts? So in that kind of a situation, when it comes down to actually having, I mean, of course, today that X bill, at least like you said, says that aspect of a mediator appointed by the participants, that is not, there's no issue. You can appoint whom you want. So that's a good thing happening there, that you don't want to touch that. But in general, you really feel that you need to regulate in terms of, because Mr. Panchu feels that there should be a register of mediators and all that kind of thing. On one on that. Second, so what are your thoughts on the training part of it, other than the certifications part of it and accreditations part of it? Is that required to be regulated, law for that, those kind of things?
Yeah, I think we have two worlds of mediation in our country. And the first is what we are looking at in this very modern sense, in this formal sense, in this institutionalized sense. And for persons to and the second world is a world of mediation that goes on with persons who we may not, in this institutional sense, identify as a neutral, and it goes on, all the time amongst us, around us, where persons in whom participants have confidence, even at the level of a difference, or before it ripens into a dispute. Um, any difference of opinion, difference of approaches are taken to persons in whom they have confidence, without this formal process, formal structure, formal definition, and they are resolving disputes. This is happening all around us, and that will continue. That's not going to require, people who utilize mediation there simply don't have the time, or the capacities, or you know to, or the resources to be able to identify, oh, this trained mediator, this credentialed mediator, etc. And so this this huge chunk of mediation that is happening will continue to happen. Insofar as what we want to do, what we are doing in this modern avatar of mediation, this institutionalized avatar of mediation, um, when we are encouraging persons to attempt mediation in their formal disputes, uh, you are going to be able to help people identify who a mediator is in terms of training, in terms of credentialing. This helps participants decide if they want to use mediator X or mediator Y, and there is a training or there is a body that is standing behind a particular mediator and saying, yes, this person has been trained by us and knows the essentials of mediation, and will be able to provide a good process for you. This also enables standard setting for mediators, and so I think there is value in training and in accrediting mediators. As we grow into areas of very narrow areas of dispute, there is also a case to be made for persons who have subject matter expertise and who mediate the dispute. There will be a call and a need for it, and there will be a certain confidence that participants are able to repose in a person who may be a subject matter expert. And I don't think we should say, oh no, subject matter expertise has nothing to do with mediation. Process training is more important, and that may be right, but I don't think we can foreclose people needing someone with subject matter expertise to mediate certain disputes. So all of this, I think, are modern needs, are more institutional needs, and I don't think we can say, no, we will have no training, no, we will not have any credentialing, no, we will have no standard setting for mediators.
But this, I think, is a long kind of discussion with you. Of course, I think the session should have been even longer because we have 2 minutes. We'll have to finish it at this step. But my only thing about the institutional aspect is a lot of discussion happens on it. There are no numbers there. Singapore Mediation Center in the 25 years has 5,200 matters, and people say, oh, Singapore is a hub of mediation and all that. 5,200 matters in 25 years. I mean, it's ridiculous. The UK has done 17,000 mediations in the whole year. And they're saying that we have all the systems of accreditation, certifications are all in place, and there is like 18,000 certified accredited mediators there. So the number, I think there's a issue, I think fundamental issue in how it's being structured. So, and on the training part of it, my issue with that is that a class distinction. A mediator is one who has this certification, but actually on the ground, the work is being done by people who don't have that. So suddenly we create a class distinction. Oh, this is not a mediator. That is a mediator. So a person who's actually the user is benefiting from, and the ones who are actually doing the work, they become second-class citizens. The ones who don't have any work, suddenly you put them onto that kind of situation. It's a little absurd. So Chitra, we'll have to maybe close it at this stage. Anything, I mean, last remarks, which I will not counter. Anything that you want to say, please.
Just probably in response to what you've said, I don't think the people who are doing the work of mediation, irrespective of what you call them, irrespective of whether you would label them a mediator or no, or give credibility to the enormous work that they're doing, they're going to continue doing it.
Absolutely.
And
So thank you, Chitra. Yeah. So 19th workshop. The time has been set because of you. So we're going to work on all these things that we discussed today. So thank you very much.
Thank you so much. Thank you.
Pleasure talking to you.